Hey there, Bill and Jackie. Just wanted to thank you so much for this amazing episode with Vicki Robin. Not only was it financially helpful, it was emotionally, spiritually helpful. It was as if she was able to walk into my soul, reach down in there, grab it, shake it, and wake it up. It's got me thinking about a lot of life choices, and some of which I'm almost ready to enact on these days. This day. I nearly jumped up and left. It was very profound. Thank you so much for all of you do for the FI community. Peace, love, and happiness to both of you and everybody out there in the FI community world. Namaste.
Hi, Bill and Becky. My name is Paul Mollenkoff. I just wanted to let you know how much I enjoy your work and thank you. I've been involved in the FI community for a number of years now, and catching up to FI is something that I've really been drawn to. I was a late starter also. At this point, I've pulled myself up to what I would call comfortably coast FI. Your recent episode with Cameron Huddleston really resonated with me, as my mother is 83 with dementia and memory issues. Some years ago, my sisters and I believe we've taken most of the steps illustrated in this episode, but we're going to get Cameron's book, Mom and Dad, We Need to Talk, just to make sure we've left no boxes unchecked. Once again, this was just valuable, life-aiding information from Catching Up to FI. Thank you so much.
I was a human before I was an attorney, and in those roles that really set me up for success nowadays when I talk about estate planning, because that's what I used to have to do, is talk about all this stuff without having the law degree.
You were a human before an attorney. Does that mean lawyers aren't human?
I always tell people I am a lawyer, but a lot of the lawyer jokes out there, some of them are very much warranted. And you know what? If we can't joke about ourselves in our own profession, then you're just not my kind of people if you can't have a little fun. We are quite literally trained to think of, well, what if this? What if that? We are the most cynical creatures on this planet. I will kill everyone off to make sure all of my little holes are plugged. And so I think that's what people have to understand is, okay, if you're going to take that route, fine. I'm doing fine and dandy. I don't need clients. Like, I'm not going to sit here and bash them. And those companies are getting documents in the hands of more people. What people need to understand is that you are sacrificing some things like counseling, like accountability. That's another big thing. Estate planning is easy. It's the people and the personalities and the relationships that make it hard. And it's so true. Typically, I love doing those cautionary tales on the podcast, but I get really nerdy about also the celebrity estate planning and how often they mess things up. And when you look at the celebrities' estate plans that have gone Looney Tunes, or you listen to like your family and friends share cautionary tales about estate stuff, that line that my husband says is typically true, where the documents are the documents, but then it's the people and the personalities and how those people are related and what the relationships are between the people. That's what typically causes things to go a little cuckoo.
Welcome to Catching Up to FI, a podcast on mindset, money, and life for late starters of any age on their journey to financial independence. I'm Bill, and I'm a late starter.
I'm Jackie, and I'm also a late starter, and we're your host. We're here to help you on your journey to financial independence, no matter where you're starting.
We're going to talk to experts, other late starters, and explore topics related to our mission.
Join us as we catch up to FI together.
All right, hello, and welcome back to Catching Up to FI. Jackie and I've had a little break. Jackie's been busy at conferences, keynoting everywhere. Weren't you just recently in New York, Jackie?
I was in the fabulous New York City. I loved it. It's a nonprofit organization dedicated to financial literacy for K through 12 teachers. I absolutely loved it. I got to hang out with teachers and so many different, like the SEC was there, regulatory agency. So I'm like, I'm so glad to see them be supporters of financial literacy. So it's been great. I've been busy, but you know what? I still miss you, Bill. It's nothing like recording with you.
Well, we got a few to do this month. We're recording in December. It's soon to be Christmas. We have some great episodes coming out. I think this one will come out in the new year. But today we have a friend of ours from the Bogleheads, Jenny Rozelle. Why don't you introduce her? Because she's fabulous.
Yeah, Jenny is fabulous. You guys are going to love her. So part of what I did over the Thanksgiving holiday is I hung out with my best friend and we did this road trip. And who became our new best friend? Jenny Rozelle from Legal Tea because we listened to that podcast. It was so fun. So Jenny is owner and attorney at Indiana Estate and Elder Law. She's been there since 2012, and she has been assisting clients create all types of estate plans, be it for a young client with straightforward needs or an elderly loved one who may need guidance on protecting a nest egg from assisted living or nursing home costs. So additionally, she helps clients in the areas of guardianship, special needs planning, probate, trust administration, and business/farm succession planning. So she does a little bit of all of it. She hosts, as I mentioned, that has become my new podcast called Legal Tea. It's devoted to promoting awareness of estate and elder law. And on the show, Jenny shares education as well as the lighter side of lawyering by pulling back the curtain on real-life celebrity estate planning, horror stories, and cautionary tales. And we'll get into that a little bit. So Jenny and her husband, Justin, live in Indiana, which is border state to where I live in Ohio, with their two basset hounds, Flossie and Mildred, and polled shorthorn cattle. When she's not at home, Jenny is likely either at Hinkle Fieldhouse cheering on the Butler Bulldogs or spending time with her family and friends or traveling on a cruise ship. So Jenny, welcome to the show.
Oh, thank you. I guess we need to end the episode now since y'all know everything about me now.
I know, right?
It's about you, but it's about figuring out this complicated thing known as estate planning.
Yeah.
And I've done it, but I probably need to redo it. And I'm here to learn a little bit about how to do it right, what documents are necessary, and the pitfalls if you don't get it organized prior to your demise, so to speak. But before we even get started, maybe we need to understand sort of what is the scope? What is estate planning?
The thing that just popped into my head is something people ask me all the time is, who are my normal clients? And that is such a difficult question for me to answer because I stay within the wheelhouse of estate and elder law. So I'm very specific in the area in which that I practice in, but my typical client looks very different across the table from me. Kind of like Jackie alluded to, I will help young families that really just need to get their basic ducks in a row, whether it's some just very basic estate planning to, God forbid, if something were to happen to them, get some guardianship provisions and some documents. So imagine that client looks like maybe their 20s, 30s, or 40s. And then my very next meeting could be someone that is 100 and have done their estate planning rodeo a few times after 100 years. But I think that when I think of estate planning, it's really just making sure that you have documents to support you in the event of incapacity or in the event of death. I think a lot of people know that it's in the event of death, and that's when things like a last will and testament comes into play. But I sure wish a lot more people would remember that estate planning also has to do with incapacity as well and supporting us in those times of our lives that very typically happen for most people.
So why don't we take it in two parts? You're such a good teacher and explainer. So you know what? Tell us, how did you get so good at explaining some of these basic things? Because you just kind of wrapped it up in about 10 seconds what estate planning is. And I think I've been explained that a million times, and that's the clearest that I've had. So how do you get so good at that?
Yeah, so I kind of have I call it funny, but I'm very grateful the career path that I've had, my professional path, I guess. And the very beginning is I came out of undergrad at Butler University, which is why I have a lot of my time in Hinkle Fieldhouse. Somehow I was smart enough at that point in my life to realize that law school was just as much as a financial venture as it was an educational one. And so I was like, maybe I should go work at a law firm and make sure that that's what I want to do. And so I started working immediately after undergrad at the firm that I now own with my husband. But back then I, of course, wasn't an attorney because I was coming out of undergrad. And so I started in very entry-level positions. Like I sat at the front desk and answered phones and helped clients that dropped in and out and worked my way at different roles around the office. And I'm so grateful for that experience because I learned how to talk about a lot of this stuff in a way that everyone can really understand before I went to law school. And so then when I went to law school, it was just kind of formalizing the things that I already knew. Also, obviously gave me the ability to work with clients. And so I always tell people that I was a human before I was an attorney. And in those roles that really set me up for success nowadays when I talk about estate planning, because that's what I used to have to do is talk about all this stuff without having the law degree.
You were a human before an attorney. Does that mean lawyers aren't human?
I always tell people I am a lawyer, but a lot of the lawyer jokes out there, some of them are very much warranted. And you know what? If we can't joke about ourselves in our own profession, then you're just not my kind of people if you can't have a little fun. So
Yeah, well, we're so grateful to have you because that is so important. It's like, it's great if you know stuff, but if you can't explain it to other people in a basic level to understand it. So that's why we really wanted to have you on the show. So I wondered about that. You didn't share that with us at Boglehead. So I'm like, I'm going to ask her that question. So you explained that pretty much 2 phases of estate planning: while you're still living, that you may be incapacitated or other healthcare type things, and then after you die. So I guess take us through some of the basics of estate planning while you're still living. And I guess most of that is from a healthcare perspective.
I would say healthcare and financial as well. So kind of the biggies that I think of are things like an appointment of healthcare representative or a healthcare power of attorney. A lot of states call some of these documents different things, but they're doing the same thing. So while I'm in Indiana, we call that an appointment of healthcare representative. If there's a listener that is in another state, you may call it like a healthcare power of attorney, a medical power of attorney. And effectively what that document is doing is saying, hey, if something happens to me, I want this person making my healthcare decisions. So that's a very important document while we're living. And as all of us know, life is very precious and things can happen to us much earlier than we really want to talk about. I see those kind of families and individuals all the time where something tragic has happened much earlier than we really want to talk about. So I think of that medical healthcare power of attorney. I also think of documents that support that person. So kind of the fancy term that gets thrown around is advanced directives. And that fancy term is basically you relaying what your wishes are as it relates to end of life decisions like artificial nutrition and hydration, dialysis, how you want pain medication. The list could go on. Typically how it works though is that these wishes are, you're just relaying them to that person. And that person ultimately has kind of the final say as to whether or not they're going to follow your wishes, which is a nice little plug to make sure we put people in right seats on the bus to make sure we have people that are going to support us in these times of need. And then for more of a financial decision making, that's when you often hear like financial power of attorney. I always say just because something yucky has happened does not mean the bills stop coming. The bills still keep coming. Uncle Sam still wants our taxes filed. And all of that still needs to happen, even though maybe some incapacity is hit. And I think a lot of people, while I'm thinking of it, when I say incapacity, I think a lot of people think of like people older that may have dementia or Alzheimer's. Everyone needs to consider incapacity that can happen even earlier. Say someone in their 30s, 40s, whatever, gets in a car accident and they're in a coma. Well, we still need those bills still being paid. We still need taxes being filed. So those are kind of the 3 biggies I think of is the healthcare power of attorney, the advanced directives, and the financial power of attorney.
Well, what's interesting for me as an emergency physician is I don't get this paperwork in the ER. Do you have any practical advice for, you put all these wishes down on paper and it's sort of for that more relaxed situation where there's not critical life defining issues going on. And I see this in the ER where I don't know what to do. Do you have any practical advice for me?
From your side of the table? Whew. Well, first of all, in Indiana, and I would assume most states have what's called a healthcare consent law, which is just a fancy name for like putting a pecking order in place for who's to make healthcare decisions for someone if they're unable to. And you don't have that document. At the end of the day, if someone does not have that document, whether because they didn't do it or because you weren't given that document, there is a pecking order in which that it shows who should be making healthcare decisions for someone, which is incredibly like noteworthy because if typically on that pecking order, it's usually the spouse first. If not a spouse, then any adult child. And you can imagine the many different families out there that have children that don't get along. And so that's a very critical need to make sure we have these documents in place. But I think that at the end of the day, from your seat, Bill, you can only be, I don't want to say held liable because that's a very lawyerly thing to say. But if you don't have documents in front of you and whether someone didn't supply them, whether someone didn't give them to you, whatever, I think you just have to operate within, I'm sure there's plenty of protections in place for medical professionals that operate without those documents as well.
We tend to err on the side of preserving life, even though the problem is it may be an opportunity to let somebody pass, where if you do preserve life and put in all these life supports, you can withdraw them, but maybe later they won't pass from their illness, whereas if you hadn't put them in place, they would. So for me, it becomes a sort of an ethical, moral conundrum sometimes as to what do I do? And you don't want anybody to die in the ER, but for some, it may be the appropriate thing to do, but you just can't make that judgment call unless your pecking order caregiver is in place with you in the ER, which makes things a lot easier. I mean, I even talked with Jay Zigmont recently about on Child Free Wealth podcast about shouldn't we chip ourselves where we can update things, we can just scan and find out this is what you want to do. I mean, we'll get these documents from people in the nursing home, and even then we don't always get them. But unless you're in a nursing home, you typically don't get them.
Yeah, it's a great point that you have. I've been in this field now for getting close to 15 years, and I keep feeling like there's going to be a better setup where like there's a better way to get these documents, and not even just medical professionals, just distributed out much more efficiently and easily. I know that there are some outfits, some companies out there that basically put healthcare documents on like a little ID card, and that ID card is supposed to be like within that person's wallet. In practice, I'm going to guess that like, I don't even know how that would work. So I guess what I'm saying is I keep feeling like there's going to be a better solution in place, but there just really isn't. Maybe it's a great Shark Tank for us all to work on.
You just gave me a great idea, because some of those documents, you could put them all on like a Google Drive or somewhere in a PDF, and you could have a QR code that you just keep handy, maybe for my daughter or whoever that might need to look at those. So I guess my next question is, so these 3 documents, I know normally they might be a part of a package when you put your will or estate plans together, but aren't these typically available for free through most states or even some hospitals?
Yeah, the challenge with that, especially the ones that are specifically through hospitals, the challenge with that is that they're only typically going to honor the documents in which are theirs. So like if you take ABC Hospital's documents to XYZ Hospital is going to be like, you have ABC's documents. So that's only going to get you so far. There are a ton of organizations out there that provide these documents very easily, either very affordably or at no charge at all. I just would caution people from pulling things off the internet that don't have I don't even want to say a great reputation, but just be very conscious of that. I, from my seat, have to end up cleaning up a lot of those documents, and sometimes it's too late. And so it's one of those things where it's like, just make sure when you do it right. And if that means that you pay a little bit, then the peace of mind that you have at that point should be worth something.
Right. And I know that most states aren't like mine. I'm in a state of Ohio, and they have a great bar association that has some of those documents, and they're all just free. And I'm assuming that since it's the bar association, they got great attorneys that make sure it's up to date. So I just want to throw that out there, because typically I do see those for free or almost nothing, but they normally will come as part of a package if you're getting your will or whatever. So I always like to think of, okay, somebody that might not be ready to get all these documents and go to an attorney, what can they do? And they could at least try to do that. I know for me, Bill, I don't know how you would, like your kids or your wife, but as far as my wishes, if I was in my final days or on life support, like if I didn't have those documents in place, my daughter would agonize over making the right decisions because I didn't. And I know I would be relieving her a bit to go ahead and put all my wishes in writing, and at least she can say, well, I did what my mom wanted. So I don't know, it might help people to think of it that way, to say you are putting an agonizing burden potentially on the person that you do want to make that decision. So that kind of got me motivated a little bit to know that I did not want my daughter to have to stress about this stuff. You know that fantastic feeling when life just clicks, when you feel fully in control and on track? Well, Bolden Planner makes that happen. Their software is right up there with some of the professional planning software I've used as a CFP professional.
I recently started using Bolden, previously known as New Retirement. It's the closest thing to a fortune teller or a magic wand that you'll find in real life. The tool turns your dreams into plans and your plans into reality, whether it's funding college, retiring early, or knowing that you can help your aging parents. Bolden gives you the answers you need to achieve your goals.
Well, with Bolden, you'll make the right decisions. Run any what-if scenarios and see how your choices shape your future. What if you paid off debt faster? What if you invested more this year? Bolden breaks it all down, and you'll make confident, informed choices that help you catch up to FI.
With Bolden, you are in control. No more guesswork or second-guessing your decisions. Bolden gives you the financial know-how to understand your options and take charge of your future with confidence.
Ready to get started and get on track with the life that you want? Head on over to go.bolden.com and then /catching up. That's go, G-O, www.boldin, boldin.com/catching up.
And you can have the documents, but it's really important to have the conversations, right, with the people that make these documents. Now, you can't make them in a silo, right? What do you suggest are the conversations you need to have?
I am always a fan of transparency. I think there's a way to craft a conversation, especially for those individuals or families that are very private. I understand that and I respect that, but I still think there's a way to craft a conversation to, at the very least, disclose like who is where, who is supposed to be picking up the baton and when. Because when people do not share that information, when something happens, everyone's just kind of looking around like, is it me? Is it you? And where did they put the documents? And so I think it's incredibly important that you share, that people share where these documents are going to be stored. I can confirm that there is no big brother out there that stores all these documents in La La Land. That does not exist, people. And so it's so important to make sure that someone, at the very least, minimally someone, but if not a few people, know where you're holding your documents securely. And beyond that, who you have put in various roles to make sure people are stepping up in a timely fashion and everyone's not just pointing the finger at each other.
Okay, so you went through the things that people need to consider while they're still living. So now we're on the other side. Okay. So I think of when people talk about estate planning, I'm always thinking about a will, and most people are, but that's not the only thing. So can you talk to us about the post-death documents that seem to be the most common estate planning topic?
Yeah. Isn't there a song like The Other Side or something? I don't know. Maybe there's not. If there's not, I feel like there needs to be one.
And look, there's another thing. We're already in Shark Tank.
Yep. Yep. Now we're going to be songwriters. I think by far the most well-known document is the last will and testament. And what's funny is people will call my office and say, oh, I need to update my living will. And living will, just of note for everyone, is a healthcare document that you stipulate what your end of life wishes are in regards to a feeding tube. So it has absolutely nothing to do with your assets. But last will and testament is probably the most well-known document in my world. And it's kind of the document also that when someone picks up the baton and wants to start an estate planning process, that's kind of the word that they hang on to, like when they make that first call and they're like, I don't know what I want or need, but I'm pretty sure I need a will. So when we're asking them kind of in the introductory phone call or whatever, what kind of documents do you have? What are you looking to accomplish? They typically will say, oh, I need to write or update my will. So I think by far the most well-known document is the last will and testament. And I think beyond that, that's really when I talked about this at Bogleheads, that there's a lot of different types of trusts out there as well. Trust planning, revocable trust planning, irrevocable trust planning. There's so many types of trusts out there that if I tried to sit here and sound them all off, we would all be asleep in about 3 minutes, myself included. And what I would say from my seat today is whether a trust makes sense for someone completely depends on the person's assets and not how much, the type of assets, what they're trying to accomplish, as well as specifically kind of their family setup as well. So it depends on if we're looking to do any kind of planning as it relates to like blended families is a perfect example of that. So trust, I'm one of those people that I don't think trust makes sense for every single person. There are lawyers out there that will say, actually my professor in law school, which as a reminder, I worked at the office during law school. I actually worked at the office full time while going to law school in the evening. I don't remember those years, but I guess I survived. My professor during law school who taught the estates class said that every basic estate plan consisted of a revocable living trust. And I just flat don't agree with that. And that's okay. I mean, we all can agree and disagree, all sorts of different things. I just think trust makes sense for some people, and it just depends on what they've got going on. And having a will is sufficient for some people too. Just depends on what they're trying to accomplish.
So Jenny, you mentioned a revocable living trust, and that is the most common one we hear. Can you deconstruct that and tell us exactly what that is? The one your professor said he thinks everyone needs.
Yeah, he's definitely not going to listen to this podcast. He's probably going to be retiring at some point really soon. And if not, then he should be. So a revocable living trust is very likely the most common type of trust out there. So before I really dive into that, I think it's important to explain that there are two generally types of trust. There's what's called a living trust, which is what a revocable living trust is under. And there's also something called a testamentary trust. So all trusts first will fit in one of those two buckets. A testamentary trust is a trust that's created in your last will and testament. So typically I see those being like trusts set up for like minor kids. So maybe we don't want kids inheriting too young, or maybe special needs beneficiaries. That's another big one. So what we're talking about is under that living trust umbrella. And a living trust is basically a trust created while you're living. So if you compare it to the testamentary trust is created after you die, because that's in the last will and testament. So you can always first split up a trust as to one of those buckets. A revocable living trust fits under that living trust bucket. And kind of the next like tier or level or whatever you want to call it under that living trust is it revocable or is it irrevocable? A revocable living trust is probably the most common out there because it is so flexible and so unrestrictive. And what I always tell people when I do that kind of trust is you honestly don't even really feel a difference. Like with irrevocable trust planning, a lot of times you have to sacrifice something, whether it's control or whatever. But the revocable trust, you have full access, full control. You can amend the thing. You can put assets in it. You can take assets out. And I think the level of flexibility and it not being restrictive at all is probably what attracts people so much to it, because often the goal that people cite when they do a revocable living trust is typically they want to avoid the probate court process. That's typically when people fall in that camp.
Okay, well, we all have a will because we all have probate, right? And so whether or not you have a will, you have a will. Can you tell us the difference between what happens to you when you're intestate without a will and going through probate versus having a will?
Yeah, you said the word that every time I say it, people are like, what word did she just say? So intestate versus testate, the biggest difference is whether you have a will or not. And so if you have no last will and testament when you die, you are falling under what are called the intestacy rules. And if you have a will, then you're following under the testate rules. So the intestacy rules, just basically a built-in estate plan for people that die without an estate plan. And because you can imagine, I think the statistic that gets thrown around all the time is like half of people die without a will. It's honestly probably more than half, but nonetheless, you can imagine that that's why we have to have these laws built into all of our state codes to support people that die without a last will and testament. And the big takeaway I think I would want listeners to take away from those intestacy rules is that they are typically not like what you would think would happen. So I'll give you an example. Like in Indiana, if someone dies without a will and they are married and have children, people are like, oh, everything's going to go to my spouse. If you don't have a will, the intestacy rules say half goes to your spouse, half goes to your kids. And people are like, what? And that's a valid reaction. You typically will hear people say, oh, she'll get everything or he'll get everything. The intestacy rules would say otherwise. So don't bank on them to really be what's going to be there to save the day, because they may not do what you want them to do.
Yeah, that's one of the cautionary tales, right? Because just like if you don't have a prenup, you have a prenup functionally from the state as well. And you don't know what your last will and testament is if you don't know the state regulations or laws. I didn't know that it would be split 50-50. And you're not going to see the kids giving back money. You can leave your spouse more financially strapped if that happens.
Yeah, I know you wanted some cautionary tales. So I actually have seen, I've worked on both sides of cases where kids have not given assets back to their parent in that exact situation. But in kind of what would feel like, oh, this is happily ever after, I did have a case where that half went to mom, half went to kids. And the kids actually, they were fine with signing things back over to mom, which everyone's like, oh, as soon as they hear that part of the story, they're like, oh, good kids. The kicker is that those kids signing it back over to mom, they have gift tax considerations that are immediately at play now because they were rightful recipient of that asset. And now that they are gifting it back to their mom, they had to utilize some of their gift tax exemption. And so people don't think all the way through those kind of things. They don't realize how quickly complicated it could get.
Oh, it becomes a gift. Great. I had no idea that it didn't just naturally transition back. There are so many things you don't know. And this is one of the reasons you need a lawyer in your field. I mean, a lot of people think, oh, I can go to LegalZoom. I can go online and do these documents myself. What do you think about those services?
This probably won't surprise you guys because I think I'm just like a weird unicorn in my profession, but I'm owning it. So I have a little bit of a unique opinion on online services, online tools for estate planning. I'm always going to be an advocate for getting estate planning documents in the hands of more people. It pains my heart when I read statistics about people that have not done estate planning or cannot do estate planning purely based on cost. I can't work for free. I do plenty of pro bono stuff, but I have a for-profit business that I have to make money for. And so I think what people have to understand is if you go through a service, a company that offers these estate planning documents online, what they are sacrificing is the level of counseling that an attorney is going to provide. We are quite literally trained to think of, well, what if this? What if that? We are the most cynical creatures on this planet. I will kill everyone off to make sure all of my little holes are plugged. And so I think that's what people have to understand is, okay, if you're going to take that route, fine. I'm doing fine and dandy. I don't need clients. Like, I'm not going to sit here and bash them. And those companies are getting documents in the hands of more people. What people need to understand is that you are sacrificing some things like counseling, like accountability. That's another big thing. I spend a lot of my time following up with clients, especially when we have trusts in place and we're trying to get them funded, just constantly bugging them about making sure our T's get crossed. So they're fine to be out there. And what the consumers have to understand is they are sacrificing some things that an attorney in the equation would offer them.
Okay, so I do have a confession to make, and maybe this is a cautionary tale, but I did use, not an endorsement or whatever, but I had a pretty good experience with Trust and Will, which is like a newer, modern way to do your estate planning. And it was like this little wizard that walked you through everything. I mean, I had a sense of what I wanted everything to be like, but at least it kind of walked me through everything and had pet stuff on there. I thought it had a lot of little things. And so I guess I took a little bit of a shortcut, but I feel like I stopped procrastinating at least and did something. But I'm hoping that works out okay. I try to be really careful and all of that. One of these days, I think I may, probably if I knew I was meeting with an attorney like you, I'd been more excited about it. So yeah. So I don't know if any other people do that, but you're right. It gets more people.
Yeah. You're like the poster child for that, right? Like, and otherwise you may not have done it. And God forbid if something were to happen to you, at least you had something in place. And I think probably just to like bring things full circle, a lot of the cautionary tales I have are things that you guys would understand. The power of like beneficiary designations and how easy those are to mess up. Those are the little things that I get really worried about is these companies will be able to get people these documents, but people also just generally don't understand the little nuances, like how beneficiary designations impact an overall estate plan, how asset ownership impacts an estate plan. And that's just something that those companies don't have that as an offering. So that's the piece that I'm like, that got documents in your hands. And that's exactly what I'm talking about. And you have the financial education to know to nip those little things in the butt, but a lot of people don't. Those are the little things I get really worried about.
So you've mentioned two things that I want to dive into a little deeper. And before we come back to beneficiaries, I want to talk about funding a trust, because this is a cautionary tale. What does it mean to fund a trust?
So if you imagine a trust is like, I'm in Indiana, so I'm going to say as a 5-gallon bucket. Trust is like a 5-gallon bucket. And what you have to do is you take assets and you put them in your bucket. And what I always tell people is if you leave your assets outside of the bucket's not going to control when you pass away. They're just kind of floating out here in la la land. And so funding a trust essentially means changing asset ownership and or changing beneficiary designations on assets to support the overall plan. And so kind of typically, we will move the property, like their primary residence, into the bucket. So that's a deed. That's going from John and Jane Smith to John and Jane Smith's trust. Or say we have a brokerage account that we went in the bucket. Those are change of ownership forms. So it's literally taking things out of John and Jane Smith's name and putting them in John and Jane Smith's trust name.
Okay. I don't think I've done that adequately.
Cautionary tale.
Yeah.
that up. It's like an analogy would be you can put money in your brokerage account, but you don't invest it. You can have a trust, but you don't fund it. It's almost exactly the same thing.
The amount of people that I see just like that, Bill, on a weekly or monthly basis would be a number that's quite shocking for most people, because they'll come to my office and they'll say, I did this trust 20 years ago, and without making them feel too bad, I'm like, okay, so what's in it? And they're like, nothing. I'm like, okay, well, let's get some things in it then.
So it sounds like Bill has a little homework to do, but I have a question for you, Bill. So did you work with an attorney on setting up that trust, or did you try to do that on your own?
No, we'd worked with an attorney, but it's more complicated than it needs to be. And we need to relook at that. Now that we're turning 60, I mean, people say every 5 years you need to revisit things because your life has changed. And that brings up another point with regards to beneficiaries. What are they? Why are they important? And how do they relate to last will and testaments and trust? Do they take precedence? How does it work?
Yeah, so beneficiaries are typically, you see them on things like retirement accounts and brokerage accounts, life insurance policies. So they are a way to place who gets that asset at your death. They are a great tool to avoid the probate court process. And so that's why a lot of people stay hyper aware of making sure beneficiary designations are on various assets, but they trump everything. And so if I say I had my life insurance that said Jackie is my primary beneficiary of my life insurance, but my last will and testament said I want Bill to get everything, Jackie's getting that life insurance policy. And that is a huge misconception. I mean, I have worked on cases where assets through those beneficiary designations have gone to ex-spouses, to parents over kids. And it's just your classic oopsies. Either they didn't understand or they didn't keep them updated, could be and or there. But that's the big takeaway that people need to hear is beneficiary designations trump what your documents state, which is why it's so important to kind of bring things full circle. When I was talking about that funding process and I mentioned it's asset ownership and beneficiary designations, depending on the type of asset, kind of tax considerations are at play, as well as what is the goal of this estate plan. Sometimes we modify those beneficiary designations to support the overall plan. So it's such an easy thing. Beneficiary designations are such an easy thing to make sure we have on assets, but they're a really easy thing to mess up too.
I mean, I've heard you've had to revisit them every year, basically, because there's death, estrangement, divorce, and many reasons that your life has changed. And unless you just go into your accounts and look at what you've done, and then there's primary and secondary beneficiaries that you need to look at too. And sometimes even tertiary. Jackie has like 12 beneficiaries for her HSA accounts.
I do. And that's something kind of new, health savings accounts. So speaking of that, so a lot of people don't think about health savings accounts as one of those accounts where you can put a beneficiary on there. And I feel like there's a list of a few other items that people don't even realize you can put as a beneficiary. So can we go through some of those that are less common so that people know these beneficiary designations can be done on a lot of different assets?
The list of assets that you can't put a beneficiary on is pretty darn small. I mean, you think of property. A lot of states, but not all, I'll repeat that, a lot of states, but not all, have what's called a transfer on death deed. Some states call it something different.
Like a ladybird deed or something in Florida.
Yes. So that's a way that you can put a beneficiary designation on property. Even on businesses, you can add beneficiaries through the corporate documents or the certificates. Bank accounts, typically, I don't know why, banks are the bane of my existence. If I ever get assassinated, it'll probably be bank because they just give me so many headaches and unnecessarily so. But another example would be banks. What they call a beneficiary designation is a payable on death or a transfer on death. Even banks call it different things between those two. So yeah, I really can't even think of, maybe something that you really can't put a beneficiary on is like personal property, like jewelry, tools,
animals, pets.
Yeah.
I didn't know that you could put a beneficiary on your house.
Yeah, depending on the state. So Jenny, does Indiana allow that? Because
Yes.
Ohio allows it. And the other thing I did not know was that you can also put a beneficiary on a motor vehicle. So I have put my daughter as the beneficiary on a motor vehicle. And I think when I looked it up, I think it was like 26 states. So check your state to see if they allow that. Because I tried to, because I was doing the quickie wheel online, I tried to put a beneficiary on everything that I possibly could, because I feel like that's the cleanest way to do it. And I revisit those as needed. But I think think some people forget about these other things. They think of it with a retirement account, but there's so many other things you can put a beneficiary
Well,
in.
how do you do it on a property like a car and a house? I mean, how does that work?
So for a property, it's actually a deed. Like it's called a transfer on death deed. And you're not transferring ownership now, like while you're living. It just basically gets recorded with the county office and it just kind of hangs out on the property records until you pass away. And then the beneficiary that's listed on that deed files an affidavit and it transfers an ownership to them at that point. So for property, it's a deed. And then for vehicles, it's like you just go through your local like Department of Motor Vehicles or I can never say that. BMV. I'm going to say BMV.
Yeah, BMV. Bureau of Motor Vehicle.
that. I can't say that word. Actually, sometimes they'll send you a new title and that title will list like Jenny Roselle, TOD, John Smith.
Yeah, that was the exact process for Ohio. I suppose every state might do it a little different, but it was so simple. And in Ohio, it was an extra step. You had to get the signature notarized on that one-page document that you have to fill out. And I'm going to the bank. I'm trying to find some place to get it notarized. Well, I go to the BMV and they would have notarized it for me for $1. I'm like, well, geez, I wouldn't have. So I was very happy to learn that. So that may be some new information that people really don't hear talked about a lot. It just helps simplify things. And I guess the other point of clarification I wanted to try to make sure I understood and that everyone else understands is that when they do have a will, that will still needs to go through probate.
It depends. That's my favorite lawyer answer in the entire world. It depends. So a will only goes through probate if, and every state has a different number for what I'm about to say, but probate is required if the assets in that deceased person's name exceed a certain threshold. And that person's name, it's assets in just their name and no beneficiaries attached. So like literally just their name, no beneficiaries attached. Like for example, Indiana is 100,000. If the assets that are in my name alone with no beneficiaries attached exceed 100,000 when I die, my will, or if I don't have a will, we're going through those weird intestacy rules that has to go through probate.
Okay, that's very, very helpful because I was so confused on that. Thank you for clarifying that. So if it is over 100,000 or whatever state you are and whatever that number is, and it does have to go through probate, the whole idea would be to try to avoid probate. You've already mentioned several ways where an asset does not have to go through probate, like if they name the beneficiary, you mentioned that, titling. So can you talk about the titling a little bit more?
Yeah, so joint ownership. So let's pretend we're talking about John and Jane Smith. John dies and maybe John and Jane Smith own their house together. So it's joint ownership. So that would just transfer an ownership over to Jane Smith. So exact same thing for bank accounts. If John and Jane Smith has bank accounts, it's jointly owned. Those bank accounts are just going to go over to Jane Smith when John passes away. And so joint ownership is, and that's why I really harp on the assets that are in consideration here are in one person's name and no beneficiaries attached. That's when we're looking as to whether are we hitting that threshold, are we under it, and we can do what are called small estate affidavits. We're going through like a small estate process. But if we're above that threshold, that's when probate's going to be required.
Gotcha. So here's another thing about, I've tried to scare some of my family members by telling them this. So hopefully I've told them the wrong thing. Okay, so if they don't name a beneficiary, let's say they have a $500,000 insurance policy and it has to go through probate. Once something hits probate, then the creditors have priority over you as the person that got named, not the beneficiary, because in this case, there's no beneficiary. So if it goes through probate, do the creditors have priority over whoever got named as the executor to get the money?
Legally, yes. What you told your family was right.
Okay.
Part of the probate court process is there's a period of time in which creditors can file claims on the estate. Now, I said legally, yes, but there's a little bit of strategy that can go on there. Like, for example, in Indiana, if a creditor does not put a claim on the court's record, it is barred. And so they have 3 months to make a claim. They don't make a claim on the court's record, it's barred. And so during the 3 months, we're just like twiddling our thumbs, like they're going to put a claim on it. And a lot of credit card companies, medical company, like they pay people to like look for estates to be able to make sure that they appropriately and timely file claims on these estates. If they don't, then I can kind of tell them to shove it where the sun doesn't shine. So technically, yes, creditors creditors have first dibs. If it's a legit claim, then yeah, they're going to get paid. And honestly, I kind of take the position, if it's a legit claim, then yeah, they should be paid. But if they don't make a claim, then I just take the position, hey, we're just following the rules. If you don't file within 3 months, like in Indiana, sorry about you. You didn't have your stuff together, so we're not paying you. So legally, yes. Yeah.
So you snooze, you lose. If you don't do it in that window, then that is it. So that makes really good sense. Okay. I just want to make sure my family and other people, listeners and everybody knows that if it does go through probate, if the creditor files within that window, then they could very well take a portion of those assets, which makes it even more important to name beneficiaries or somehow have your assets set up to where it doesn't have to go through probate.
Yeah. If I could add one little thing, because it's something that it kind of frustrates me sometimes in like a nice way, because I'm a very nice person, but it frustrates me sometimes when people get so laser focused on avoiding probate that they forget to kind of look at the bigger picture. And so a perfect example of what I mean is people will go on this like tirade of like, I got to get beneficiaries on everything. And then I'm like, okay, that's great. Let's talk about your family. And then I learned that their kids don't get along, or maybe one of their beneficiaries has special needs. And if they inherit, they're going to get kicked off of governmental benefits they're entitled to. And so I just beg people to make sure that if we're relying on beneficiary designations, that's a huge cautionary tale I have. That I had a case where someone did a transfer on death deed for, it was dad. Dad passed away, left his house and rental property to his 2 kids, who I would have never guessed that they would fight. Dad passed away. One of them turned into a person that I never saw, like figuratively, and they ended up going into total gridlock. And what ended up happening was getting a judge involved to force a sale of the property. And so it's a perfect example of like, okay, he was so gung-ho about avoiding probate, and he didn't want to do the trust planning route. He wanted to do a will with those beneficiary designations. That bit him in the rear because his beneficiaries didn't end up getting along. And so there's just other things to consider. Like, I know that avoiding probate through beneficiary designations is a very common strategy, and it's a common strategy that I'll support if it makes sense on all other fronts.
Okay, I need to get myself in check. You're not doing it, but I can feel you wagging your finger at me saying, Jackie, I'm talking to you. No, and this may be the obvious, but can you just quickly tell us why people hate probate so much? It sounds like it's just overdone, the hate for probate.
Yeah, I think I talked about this at Bogleheads. And again, I kind of take a little bit of a unique position on probate. Some states, the probate process is pretty brutal, but I think professionals, lawyers, try to scare people from that probate word. And I come from an approach of like, okay, let's educate people on what that word is, and then let them decide if they give a hoot about it or not. And there's 3 non-negotiables about probate. I always tell people, time, it's not going to happen overnight. In Indiana, if it happens in less than a year from start to finish, you should go buy a lottery ticket. So time-wise, it takes a little while. Cost, it cracks me up when lawyers try to say probate costs. It's totally the legal fees. Legal fees kind of range they're sort of all over the board, whether it's hourly or whether it's like a percentage model, but your executors have to hire a lawyer. So that's like kind of a textbook monopoly. Like my only competition are other estate attorneys. So time, cost, and public record. So sometimes people are really concerned about having their estate administered privately. And so being able to avoid that process, anytime you're going through the court, it's public record. And so probate is public record then. So as long as I explain those 3 things to clients, and I'm like, these 3 things are going to happen. And sometimes clients are like, well, I don't really care about any of those. I'm like, then if you don't care, I don't care. A lot of states, probate's really not that bad. Indiana's one of those states. I like probate cases because they're typically higher dollar clients, higher dollar cases, but to act like it's like some scary nightmare come true is false. I mean, I have never stepped foot in a courthouse for probate. Like, it is all electronically filed. It's not scary. It's just a process.
Well, I mean, people get intimidated by the complexity and then the cost. Probate has a cost, and estate plans, including trust that can be more complicated, have a cost. Can you give us a range that people should expect generally? It's hard. I know it can be, given hourly fees, dramatic, but what could the average person that needs a simple living trust and the main 4 documents in their estate plan, what can they expect? And are there flat fee models? Is it hourly models? Is it all in between?
Most of the time, estate attorneys are in the flat fee hourly model. Unless you're in kind of the higher net worth space, then they are typically hourly models. But most of the time, attorneys will do flat fees. Granted, myself included, I always joke with clients, whether it's you or Bill Gates sitting in front of me, if you and Bill Gates are doing the same plan, it's going to be the same fee. Indiana is a low cost of living state. So if we were sharing this screen with an estate attorney in New York or California, they'd be like, oh my gosh, that's all you're charging. But these are kind of reasonable fees for around my area. And I would say anyone that has kind of a cost of living similar to Indiana's. Typically in those kind of basic 4 documents, the healthcare, the financial power of attorney, basic last will and testament, that kind of plan I'm typically doing for like young families. Somewhere around the 1,000 mark for whether you're single or married is close-ish. Married couple maybe closer to like 1,500-ish. Trust planning is going to be every day of the week into the thousands, but not like 10,000. Like for a revocable trust plan through my office, it's going to be $4,000 to $5,000 depending on what other of those documents that you need. The basic ones we talked about, whether you're single versus married, whether we're doing tax planning strategies or not. And then my office does a lot of the elder law side of my practice is doing irrevocable trust planning for long-term care costs and trying to protect assets against Medicaid. Those are typically in like the 5,000 to 6,000 to 7,000 range, again, depending on all those same details. But I know people are much lower. Some attorneys would say, oh, that's too high. Well, I'm valuing the level of service that I'm providing because we also do, as part of our process for trust planning, we do all that funding, that bill that you have slacked on a little bit, we do as part of our normal process. So like when people sign the trust document, the finish line's not there. We do all the funding for clients as well. And alternatively, there's attorneys that charge significantly more, and those typically are in higher cost of living states.
Okay. And how does that compare to the cost of probate? Because people forget, because that could be an hourly model. Is it generally potentially more expensive to go through probate?
For sure. I want every listener to know that I did not plant Bill to ask me that question. It is, like I said earlier, my office likes probate cases. Anytime that I'm having to work more is going to be a higher dollar case. Typically, probate attorneys will charge a percentage of the estate. It is one of those things that it's an attorney-specific number. Sometimes states have set parameters in which the percentage that the attorney can charge for probate, you'll sometimes see that in some states. It could be as low as like a half to a 1%. It could be as high as 4, 5, 6%. So you do the math of your estate and your net worth, and that's probably what the probate fee would be. I think I talked about this at the Bogleheads conference that ethically, technically, attorneys are supposed to sprinkle reasonableness on that fee. And so if that fee ends up being something absolutely astronomical, they're supposed to be in comparison to the level of time and work that fee would generate. Whether that happens, I'll let people decide. But
And you know, Jenny, in preparation for our call today, I did a little research in the state of Ohio, and they do have specific language that says that for an estate attorney, like if it goes through probate, what they can charge is capped at a certain amount. So it's already written in there. So to your point, they can't get too crazy, and most states might have a cap on that.
you should follow a little follow-up to do for you, Jackie, is, for example, Indiana has that, but they only have cap percentages for what are called supervised estates, which are typically reserved for cases where families are fighting. But if it's like a very traditional, like normal old probate, we don't have to go by those capped percentages.
Geez, why can't anything be easy, Jenny? My goodness.
Well, you should look and see, because that's how Indiana is. We have the percentage caps for supervised, but there's no cap for unsupervised.
Yeah, I just know that the laws of Ohio and the laws of Indiana are very, very similar. That's why a lot of the things you're saying, I'm like, yeah, that's what I found in the state of Ohio as well.
Yeah. Yeah.
Wow. Okay. So I don't know about you, Bill, but I definitely have some homework, and we want to definitely hear a couple of those cautionary tales and the real life stories. But I do have a general question. So we just had an election, right? We've got a new administration. You've got the Tax Cuts and Jobs Act, and you had a really, really high estate amount before you have to pay taxes. So is there anything we need to look for as far as changes from an estate planning perspective?
I mean, that's the biggie. I actually, little insider secret, I think that that's my next legalty episode that should drop tomorrow. I think is estate tax planning post election. That's the big one, is whether or not they are going to decrease the estate tax threshold, the estate tax exemption amount. The good news, it technically wouldn't take effect until December of 2025. So we have a whole year to sort of watch and see what ends up happening. I typically follow what is the law as it's written right now. If I tried to pivot for everything that I hear that's going to happen and then doesn't end up happening, oh geez, I would spend all my day chasing my tail. And so as it's written now, the estate tax threshold is supposed to reduce at the end of 2025. And so I am still encouraging clients to take that into consideration, whether it's just basic estate planning now, or whether it's tax planning strategies through fancy irrevocable trust plans to just in case they let it sunset. Yeah, so that's the big one to keep our eyes on.
So Jenny, people don't get too worried. You mentioned the threshold as it is today for the estate tax and what it's supposed to go down to if it gets sunset if nothing changes.
Yeah, it is today $13.61 million per person. So as a married couple, you get 2 of those. If that fits you, I ask you to adopt me. I am willing.
I know, right?
And it is supposed to sunset. They don't have a specific number because it depends on all the inflation, all that sort of stuff. Kind of the rule of thumb is it's likely going to be cut in half if they let it sunset at the end of 2025. So cut that basically in half per person again, 6-7-ish million or so per person.
Yeah. So these are really big numbers.
Yes.
I have me or Bill, I don't think have an issue, especially with the 13 million, the 6 million. I don't know, Bill, maybe we can get rocking and rolling and we might get it. But Jenny, the only reason we brought you on the show really is to hear some of these juicy stories. Bill, did you have a favorite one?
Probably have time for a couple, but what's like the most recent or maybe the most common? And we need to look at 2. We haven't mentioned our late starter audience, people that get started late on their road to financial independence. I don't know if there's anything different for them. Maybe they've gotten a late start on their estate planning too. But yeah, cautionary tales that are metaphoric, what we need to do and learn from the mistakes of others.
Yeah, I mean, definitely the big ones involve property. Like you think of like deed work. People will try to pull deeds online and record them, they prepare and record them themselves. That is just a disaster. It is an absolute disaster because I am in Indiana and I have a lot of farm families that do deeds, I want to say on a napkin, but not literally, where they just do these handshake deals. And that will bite you in the rear eventually. If not you, your kids or your beneficiaries down the road. So property ownership is a huge mess up that happens all the time. I do a ton of legal tea episodes on property ownership gone wrong, and beneficiary designations, single-handedly another big one. I mentioned the one earlier, that gentleman passes away and he had been divorced for a handful of years, but he left his ex-spouse on as beneficiary of his life insurance and retirement accounts. And a lot of people would be like, oh, the divorce decree would take care of that. The divorce decree was not even worth the paper it was on, to be honest, because it instructed the parties to change beneficiaries, but it didn't state what would happen if they didn't change beneficiaries. And so the retirement institute, the financial institution, and the life insurance company both made the checks payable to ex-spouse. And kind of to add to the muddy waters, the gentleman had one daughter. They had a very strained relationship. And so she filed suit against ex-spouse, that was not her mom, to recover those proceeds. But who's to say that he didn't want those proceeds to go to the ex-spouse? I mean, especially because there was such a strained relationship between him and his daughter, he may have just said, heck with it, I'm leaving him on there and they can duke it out later. And so it turned into World War III, and it just recently, I think he died probably 3 or 4 years ago, and it just got settled a few months ago. And so beneficiary designations are also the big one that people mess up on all the time. You mentioned something earlier, Bill, about how often you should kind of take a look at these things. And something that was a light bulb when you were talking was, I've even seen where financial institutions have like bought each other out. And in that transition process, they've lost the beneficiaries that are listed on there. And so just another little quirky thing to like, I know it's annoying, but just to constantly look at those beneficiary designations and make sure they're still on there, make sure they're still accurate.
I've seen change custodians. I mean, I recently moved from Vanguard to Fidelity, and you have to redo all of that. Those don't transfer. Fidelity at least reminds you to do it on a to-do list, but you've got a bunch of accounts to go into and designate who you want to go where.
Yeah. Yeah.
Well, I think another time that comes up is when people leave a job or leave their company and they're rolling over their 401k to an IRA. They have to set up the beneficiary for where the money's going.
Yeah. I think that this is probably a beautiful way to kind of wrap things up. My husband is who I co-own the law firm with. He's an attorney as well. And I always steal his line. He always says, estate planning is easy. It's the people and the personalities and the relationships that make it hard. And it's so true. Typically, I love doing those cautionary tales on the podcast, but I get really nerdy about also the celebrity estate planning and how often they mess things up. And when you look at the celebrities' estate plans that have gone Looney Tunes, or you listen to like your family and friends share cautionary tales about estate stuff, that line that my husband says is typically true, where the documents are the documents, but then it's the people and the personalities and how those people are related and what the relationships are between the people. That's what typically causes things to go a little cuckoo. And unfortunately, estate planning documents are only going to get you so far when it comes to those sort of things. I know people's brains go to like my client war stories, but I think of all the celebrities and their terrible estate plans too.
Yeah. And then we had the prenup guy on. I forget prenups too, where a lot of this can be addressed. This is important stuff. And if there's one thing that we want our audience to take away from this is they've got to look at it. If you have a to-do list or a checklist, we'd love for you to share it with us, because these are the things that are on your to-do list. And rather than let it be overwhelming, do 1, 2, 3, and find yourself a professional, not necessarily a general lawyer here, especially if you have a more complicated estate. Somebody like yourself who specializes in this stuff and knows the nuances of it so that you get it right the first time. Build a good foundation. Spend the $5,000, and then you will have so little headaches and regrets later. It's kind of like getting your house ready for your kids. You don't want to leave a mess behind. And I worry about this with my mother. She just recently allowed me to be a joint signer on her checking account so that if she becomes incapacitated, I can pay the bills, which is a good thing to do. It'll have trust involved there. And then, as you mentioned, it's the people that make it complicated, because when it's about the money, the claws come out. The hidden person inside that person where it's like, yes, show me the money.
So I want to encourage everyone to listen to the Legal Tea podcast. Jenny does an awesome job. And like she said, she talks a lot about celebrity estates. She's done Elvis Presley, Aretha Franklin, Farrah Fawcett. So besides your podcast, Jenny, where can people find you?
Yeah, kind of professionally, people are welcome to check out my website, my firm's website, indianaestateelderlaw.com. I'm on LinkedIn. I don't want to say personally, but I'm a little bit more informal on Twitter, or X, I guess. Gosh, X. It'll always be Twitter. Jenny Rozelle, and people are welcome to follow me on there as well.
We need to mention too that we don't want to send a bunch of calls from all over the country to you because you practice only in Indiana. But if you're in Indiana and you need a fantastic estate and elder care lawyer, you found the right one here on this show. So Jen, thank you so much for being on the show. We really appreciate it. We look forward to seeing you again, hopefully at Bogleheads, and interacting with you as we go on. And when we have other questions, we're coming back to you.
Okay. I can't believe it's already been an hour. So I think that time flies when you're having fun.
Well, Jenny, thanks for joining us on the show. We'll catch you next time on Catching Up to FI. So, Bill, as you know, we cannot do this show without our amazing staff and the people that help us put this on. Our social media maven is Diana Falk, and our editor is Fritz Brazard. We love them, and they keep us going.
Yeah, Jackie, I mean, this show wouldn't have the quality it has without our folks, our peeps. And we'd also like to give you a few calls to action for the show. We love our community, and we hope you love us back. If you would like to support the show and our mission to help late starters, you can do that at Buy Me a Coffee, which is a platform that allows you to make a donation. The link is in the show notes and on the website.
Check out the show notes for resources mentioned in today's show. Also, head on over to our website at catchinguptofi.com and check out our vetted resources, partners, and affiliates for discounts and their services, because we love sharing great deals.
Please share the show with others and head on over to our Facebook community to help us grow. If you prefer video, head on over to YouTube and watch the show there. We hope you've enjoyed this episode of Catching Up to FI. We would appreciate it if you could also leave us a 5-star review to help our message reach others.
And while we are financial educators that love to teach, remember that our content is for general education and information purposes only. We are not providing financial, legal, or tax advice. Always do your own research or consult a professional before making important decisions.
So, Jackie, we'll see our audience next time on Catching Up to 5. Cheers.